Good afternoon. I'm Ali Amida, School of Social and Behavioral Sciences at University of New England, and this is Constitution Day for the year 2025. I'd like to thank Carl for managing the recording, and also thank all of you for coming in this beautiful day and resisting the temptation to walk and have a good day outside and be here with us for this annual event. We are organizing Constitutional Day in compliance with the federal government and the legislating memo that was issued in 2004, led by the late Senator Jim Byrd. And basically, the late senator, he was alarmed that most Americans, they don't know the Constitution. After all, we are a republic, as far as I know, and the things that really, common to all Americans is the fact that we are a federal republic. And the Constitution is really the main reference for all of us in this country. So the concern was that because there is no awareness or in-depth knowledge of the Constitution, all institutions of higher education are required, based on this legislative memo, they have to organize one day around September 17th. And this day is devoted to discussions, education, debates, conversation regarding our Constitution. Most of my colleagues in other institutions, they really, they laugh at the idea. They say, Ali, this is really boring. We are required to do this and so on and so on. And I think I have to say that at UNE, we really turned it to something very interesting, a forum for conversation, for civility, for in-depth exchange of ideas. And often we have students or faculty or some of our, some visitors. But sometimes, like today, we have one of our colleagues who are expert in aspects of our Constitution and our political system. So this is really a very, very important event. And I think our history of organizing this event has been very successful, and I would say should give us a very, very good pass with the federal government and the Department of Education, if it still is with us. Of course, the Department of Education, as you know, is reorganized now. Today's speaker is a colleague, a new colleague of mine, Professor Ryan Williams, and he is, to my delight, is really expert on aspects of the Constitution that are very relevant for today's topic. And Professor Williams is assistant professor of criminology and sociology in the School of Social and Behavioral Sciences. He is by training as a political scientist and received a PhD from University of North Carolina. And his expertise on the area of constitutional politics, governance, and when I asked him, we came with the idea that maybe the Supreme Court and the Imperial Presidency would be a good topic. And I loved the proposal, and I thought maybe this is a timely topic for us at UNE to explore this aspect of our Constitution and maybe reflect about the challenges that our society now faces with a lot of divisions, a lot of bitter arguments, and accusation and counter-accusation. So perhaps this will, calm the temper and temper the sentiment and give us some insights about how to think about the Supreme Court and the Imperial Presidency. So without really further ado, I'm going to ask Professor Williams to give us 25 minutes overview of his thinking and how to think about that dilemma, especially when one party dominates three branches of government, and to what extent our current president, President Donald Trump, really fits previous patterns of imperial presidency. So I will let him give us his take and insights about that, and after that, as we do usually, we'll open the floor for comments and questions and conversation. So, Professor Williams.
So thank you very much for that very kind introduction, Dr. Amita. I'm honored to speak at this year's Constitution Day event at UNE, especially as a relatively new member of the faculty. As Dr. Amita noted, I am an assistant professor of criminology. I teach classes on criminal justice, criminology, and political science. But my particular area of expertise is U.S. law and courts. Specifically, I study the role of our courts in the criminal justice system, how judges make decisions, and the relationship between judges' behavior and public opinion. Now, my presentation today is going to focus on judicial behavior. And the subject of today's talk is the Supreme Court and the Imperial Presidency. In more simple terms, we are talking about presidential power and how the U.S. Supreme Court plays a role in limiting that power or enabling its expansion. Now, this is a topic that certainly is a timely one that's ripped straight from the daily news headlines. So let's consider a few examples. First, in June 2024, the U.S. Supreme Court ruled that presidents cannot be criminally prosecuted for actions they've taken that fall within their core constitutional functions. And what's more, presidents likely can't be prosecuted for any official acts they take. So very simply, this means that presidents can't be held criminally liable for most actions they take while in office. Second, in the 8 months since President Donald Trump returned to office, the Supreme Court has allowed key parts of the administration's priorities to move forward. With respect to immigration, the court has allowed the administration to end the protected status of more than 300,000 Venezuelan nationals living in the U.S. And another order from the court revoked the permission to stay in the country for more than 500,000 non-citizens from several countries. These are individuals who had previously been granted permission to remain in the U.S. for humanitarian or public interest reasons. The court has also allowed the administration to proceed with its goals of reducing the size of the executive branch of the federal government and giving the president more control over federal agencies and federal employees. The court has issued orders allowing the president to continue with the mass firings of thousands of federal workers across agencies, to proceed with the dismantling of the Department of Education by firing over 1,000 employees, and to unilaterally fire members of independent federal agencies. Other administration priorities, such as issues relating to LGBTQ+ people and law enforcement, also are moving forward due to Supreme Court orders. This includes a ban on transgender people serving in the military and greater freedom for federal law enforcement agencies, such as ICE, to stop people for immigration reasons. And finally, in June of this year, the Supreme Court ruled that lower federal courts cannot issue universal injunctions under ordinary circumstances. To clarify, an injunction is a court order to stop doing something. For example, if you think an action the president has taken has legally harmed you, you can ask a court for an injunction to block that action from applying to you while courts decide if the action is legal. Compared to a regular injunction, a universal one goes further. It is a nationwide block on the policy. This means the policy is blocked from affecting everyone, not just you. So for lower courts, if they can't grant these universal injunctions, this means the only thing they can do is block the action from affecting just the person who filed the lawsuit. And this ruling especially benefits the president. No longer can a president's actions be blocked throughout the country in one fell swoop. Now the president's policy remains in effect everywhere except for the specific person or group of people who filed the lawsuit against it. All of these decisions or orders from the court have come in just the past 14 months, a little more than a year's time. And the common factor linking these examples together is that in each one, the court's decision has expanded the president's power or given a victory to the president. So today's presentation is an exploration of presidential power, what the US Constitution says about it, how this power has expanded over time, and the role the US Supreme Court has played in traditionally limiting or checking presidential authority, but more recently, working to enable it. The central thesis or argument is that the current US Supreme Court's treatment of presidential power is unique. Compared to previous Supreme Courts, the current court is more partisan and more aggressive than previous Supreme Courts when it comes to deciding cases that deal with presidential power. More aggressive because this court rules against the president at higher rates than any other modern Supreme Court since the 1930s. But more partisan because this court is more willing to check or limit presidential power when the president and the Supreme Court majority are from different political parties. For the current Supreme Court that has 6 Republican-appointed justices compared to 3 Democratic-appointed ones, research finds that this court is opposed to greater presidential power when a Democratic president is in office. But when it comes to a president that shares their same party affiliation, the justices are much less likely to rein in the president. Instead, this Republican majority court is willing to expand the executive's authority when there is a Republican president. And we see that with the examples I discussed above. Now, to support this claim, I'm going to be referencing some great recent research from political scientists and legal scholars, like Rebecca L. Brown, a law professor at the University of Southern California. Brown sums up the relationship between the current Supreme Court and presidential power today by stating that, quote, "The president wins because we, the court, think he's right." Before exploring this argument, though, I want to talk about some basics about presidential power in the Constitution. So to understand presidential power, we need to understand first the system that the Constitution sets up for how presidents work alongside the other branches of government, right? So these are concepts that we're all familiar with, right? So in particular, there are 2 foundational concepts that are important here: separation of powers and checks and balances. Framers of the Constitution recognize the dangers of giving just one person or one branch all or most of the powers of government. As James Madison wrote in Federalist 47, quote, "The accumulation of all powers, legislative, executive, and judiciary, in the same hands may justly be pronounced the very definition of tyranny." So to avoid this tyranny, to protect the rights of the people, the framers wrote a constitution that divides the 3 basic functions of government across 3 separate and independent branches of government. So the term separation of powers doesn't specifically appear in the US Constitution, but the concept is really clear if you look at the first 3 articles of the Constitution. Right? Article 1 deals with the legislative power. Right? It outlines what the legislative branch will look like, what the powers this Congress will have. Article 2 sets up the executive branch, sets up the office of the president, describes how the president will be elected, and lists several presidential powers and responsibilities. Article 3 establishes the judicial branch, creates the US Supreme Court. So the framers tried to make sure that no one person or branch had all the powers of government. But they also went one step further, right, to try to prevent any one of these branches from becoming too powerful. Specifically, the branches would not be able to take key actions without the other branches being involved. So in other words, one branch was given power to check the others. So the logic behind this system of checks and balances comes again from one of the Federalist Papers, famously number 51, again written by James Madison. Madison tells us, quote, "The great security against a gradual concentration of the several powers in the same department consists in giving to those who administer each department the necessary constitutional means and personal motives to resist encroachment of the others. Ambition must be made to counteract ambition. If men were angels, no government would be necessary. In framing a government, which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself." So the Constitution creates a system of government where power is separated into three branches of government, each with checks that prevent any one branch from gaining too much power. We can think of many examples of this, right? Congress is the legislative or lawmaking branch, but it can't pass laws without the president approving or signing those laws first. Another example, the president appoints Supreme Court justices, but the Senate has to confirm the president's choices. So the president's place in this separation of powers, checks and balances system, and her powers of office are mostly described in Article 2 of the Constitution. There are other examples elsewhere in the Constitution. Article 1, for example, tells us that the president has the power to veto or reject the laws that Congress has passed. But we're really looking at Article 2 for where the president's powers are located. Article 2, Section 1, for example, gives us the vesting clause, right? The vesting clause says that the executive power shall be vested in a president of the United States. Article 2, Section 2 lists some of the president's key powers and responsibilities. It makes the president commander-in-chief of the armed forces. It allows the president to grant pardons. And it gives the president the power to make treaties with other nations and to nominate judges, ambassadors, and the heads of agencies, right? Subject, of course, to confirmation by the US Senate. And then importantly, Article 2, Section 3 contains the Take Care Clause, which tells us that the president shall take care that the laws are faithfully executed. Now, there are other roles and responsibilities for the president that are described in Article 2, like providing a State of the Union to Congress or receiving ambassadors as the chief diplomat. But what I've just told you is most of what the Constitution says about the powers of the president. And some of the powers I've described are very vague. For example, what is fully meant by executive power? What can the president do under the requirement that he take care that the laws are faithfully executed? When does the power of commander-in-chief begin? And what activities or circumstances does it cover? These are questions that are at the heart of court cases about the extent of presidential power. And while we're still working out those answers, it is clear from the trajectory of American history that the modern executive has become more powerful than was intended or even imagined by the framers. Notably, right, the president of the first 100+ years of the country was a relatively weak one, and this was intentional. While the Constitution doesn't create a hierarchy among the three branches, the framers do seem to have intended that Congress would be the dominant branch of the federal government. Now, importantly, the presidents of the 18th and 19th centuries lacked the modern tools that, by the mid-20th century, would transform the presidency into the power center of government. Today, there are more than 2 million people who work in the executive bureaucracy across hundreds of agencies that are specialized in all policy areas. The pre-20th century presidents didn't have the expertise of this bureaucracy, especially the access to information that these agencies provide that assist the president in making decisions so she can act quickly. Now, the president's policy role also was limited by the US's more isolationist foreign policy at the time. Today's president is a global leader, but early presidents were not front and center on the world stage. So this meant that legislating and policymaking were largely left up to Congress. And as the noted presidential scholar Stephen Skowronek wrote about one of these 19th century presidents, Franklin Pierce, who was president in the 1850s, quote, "No interest of any significance depended on the president's success." But the role and power of the presidency greatly changed by the mid-20th century. Growth of the bureaucracy, the emergence of the US as a global superpower after World War II, and the country's military and economic strength all contributed to an empowered, modern president that replaced Congress at the center of American government. This was in part due to the US's role on the world stage and the need for an energetic and decisive decision maker who could make decisions quickly in times of crisis. By design, Congress is slow to make decisions. It has 535 members who have to reach majority agreement to pass laws. But the president is one person who is able to act quickly. So given this, it's really not surprising that its foreign policy and military action for presidential power especially grew in the 20th and 21st centuries. Under the Constitution, war-making powers are shared between Congress and the presidency. Congress is given the power to declare war and support armies, while the president is the commander-in-chief of those armed forces. But history shows us the dominance of the president in these areas. Congress hasn't declared war since World War II. But the US has fought conflicts in Korea, Vietnam, Afghanistan, Iraq, and countless others. Presidents have taken military action without congressional approval or notification, despite attempts over time by Congress to try to limit the president's ability to do so, like in the 1973 War Powers Resolution. Now, interestingly, Congress has actually given power to the president in this area. It's actually delegated explicit authority to the president. Congress has given the president more resources in foreign policy and defense by passing laws that create new agencies like the CIA or the Department of Homeland Security, and new positions like the Director of National Intelligence, who is the president's primary advisor for national security-related intelligence. Congress has also given the president broad authorization to use military force with little restraint, including in Vietnam, Iraq, and Afghanistan. And with the Patriot Act, Congress provided the executive greater surveillance and terrorism-fighting powers. So by the 1970s, the power of the presidency had reached a point where many were questioning how far presidents could go in exercising these powers and whether such actions were constitutional. This brings us to the term the Imperial Presidency. It was popularized in a 1973 book by historian Arthur Schlesinger Jr., and the Imperial Presidency is really a situation where the executive branch, the president, has gained more power than the US Constitution allows, such that the separation of power system that our Constitution sets up is being jeopardized. This often is taken to mean that when what the president has gained, the other branches have lost. Now, a more recent version of this imperial presidency is what's called the unitary executive theory. This is a belief that the Constitution gives the president full control over the executive branch and immense powers to act alone without the other branches. This is a very broad interpretation of executive power and is supported by those who really want to see the strongest possible version of a US president. Unitary executive advocates justify their argument by pointing to several parts of the Constitution, namely ones we've already talked about, the vesting clause and the take care clause. They argue that the vesting clause, when it says that executive power shall be vested in a president of the United States, this means that the president has all executive power, not just some, that the president does not share executive authority. Essentially, what they're saying is that the executive branch is the president. Similarly, when they are looking at the take care clause, they're interpreting this to mean that the president can do whatever is necessary to make sure that the nation's laws are carried out. And it's really two key areas where the unitary executive theory says the president should have this virtually unchecked power. The first is with respect to executive control over the bureaucracy. So this means that the president should have the ability to fire and direct any and all subordinates in the executive branch at will. And second, the unitary executive theory that really emerged in the George W. Bush presidency was with respect to what are called, quote, implied inherent foreign policy powers. Now, the unitary executive theory has found a home in the Trump administration, particularly given the administration's focus on reducing the size of the executive branch and its argument that the president should be able to hire and fire the heads of executive and independent agencies at his discretion. So it seems clear that the current presidential administration is interested in expanding its authority. And without doubt, the power of the presidency has expanded over the course of American history. But this brings us to the question of how the Supreme Court has factored into this expansion. Because presidential powers are not clearly defined in the Constitution, questions about whether the president has gone too far end up in the federal courts. So it's the judicial branch that tells us what presidential activities are acceptable and which ones are not. The Supreme Court said this in one of its most important cases, Marbury versus Madison. Quote, "It is emphatically the province and duty of the judicial department to say what the law is." Now, historically, there are significant cases where the Supreme Court has served as a check on presidents attempting to expand their power. A few notable examples are worth exploring. First, during the Korean War in the early 1950s, President Harry Truman was worried about the effects a strike of the nation's steel workers would have on the war effort. So Truman ordered the country's steel mills to be seized by the federal government and for the federal government to operate these mills. Steel companies sued, and the Supreme Court ruled that Truman had unlawfully seized the mills, that the president's constitutional powers, including through the Take Care Clause, did not grant him this authority. President Truman complied with this decision. During the Watergate scandal of the 1970s, President Richard Nixon argued that he did not have to turn over incriminating tapes because he had executive privilege that allowed him to withhold information from the other branches. The Supreme Court said that executive privilege is limited and not relevant in this case, so Nixon had to hand over the tapes. Nixon did so and resigned soon after. And during the George W. Bush administration, the Supreme Court ruled against the president in 3 cases that upheld the rights of Guantanamo Bay detainees. So together, these cases and others like them demonstrate that the president and the executive branch is subject to the law, and importantly, the Supreme Court's interpretation of its powers. And aggregate data from scholars Lee Epstein and Rebecca Brown support this claim. Since 1953, in high-stakes cases dealing with presidential power, the Supreme Court ruled for the president about as often as it ruled against him. And interestingly, the current Supreme Court rules against the president in these cases about 65% of the time. So it would seem that the Supreme Court, both historically and currently, is a reliable check on presidents trying to push their powers past what the Constitution allows. But to quote the great college football analyst Lee Corso, not so fast, my friend. So for decades, political science research has shown that the ideologies of Supreme Court justices affect the decisions they make. Liberal justices are more likely to make liberal decisions. Conservative justices are more likely to make conservative decisions. As Justice Benjamin Cardozo once said, "We judges like to figure to ourselves the processes of justice as coldly objective and impersonal. But the great tides and currents which engulf the rest of men do not turn aside in their course and pass the judges by." But what's more recent is how a justice's ideology now matches with their partisanship. In the past, knowing that a justice was appointed by a Republican president meant you could often, but not always, reliably predict that the justice was more likely to vote conservatively. There were some justices, for example, who were less conservative than expected, and some justices who were Republican appointees but consistently voted in a liberal direction. But as Professor Epstein shows us in a recent, different study, by 2010, the Supreme Court was perfectly sorted, meaning that all Democratic appointees exhibited liberal ideologies, and all Republican appointees were conservative in ideology. And when it comes to cases dealing with presidential power, the Epstein and Brown study finds that this current Supreme Court displays a greater pattern of partisan voting than any previous Supreme Court. Based on their models, in high-stakes presidential power cases, the 6 current Republican justices are 30 percentage points more likely to vote in favor of a Republican than a Democratic president. Democratic justices have similar voting gaps. And what's more is that this partisan voting is even stronger when the president appointed the justice, which means that for the 3 Trump appointees, Gorsuch, Kavanaugh, and Barrett, the gap between voting for Trump versus a Democratic president only widens. So the partisan decision-making of the current Supreme Court, in this way, right, the justices seem to be acting just as polarized as the American public and elected officials throughout the country. Now, the partisan decision-making we are seeing from the current justices on issues of presidential power in particular is perhaps strongest when we look at a special type of the court's cases. These are what are called emergency applications. These are petitions that ask the Supreme Court to take immediate action, often to block a policy or a lower court decision from going into effect. Emergency actions are decided relatively quickly with brief orders that have little or no explanation. The Supreme Court has increasingly decided emergency applications dealing with important policy issues, including presidential power. And presidents are asking the court for emergency relief through these applications to a greater extent than ever before. The Trump administration has filed more emergency applications in its first 8 months than the Biden administration did in its entire 4 years. And the success of Trump compared to Biden on these applications reflects a Supreme Court controlled by majority Republicans. While Biden was successful in 53% of his administration's emergency applications, Trump so far has won 84% of the time. Now, many of the rulings that I started this presentation with are emergency applications and part of this 84%. These are situations where a lower federal court has temporarily blocked a Trump administration action or policy from going into effect, but the US Supreme Court has reversed the lower court and allowed the Trump policy to continue for the time being. So what this means is we have a current Supreme Court uniquely partisan in its decision-making, particularly on presidential power and especially on these emergency applications. This is a court majority that is more than willing to check Democratic presidents, but equally okay with expanding presidential power under Republican presidents. Now, as a final example of this point, let's return to the Supreme Court's June decision to eliminate universal injunctions. Like the current Trump administration, President Biden's executive branch also requested that the Supreme Court limit or end these injunctions. During his presidency, Biden's policies were subject to universal injunctions from lower court judges that were blocking these policies from going into effect. But the Supreme Court declined to grant this request while Biden was in office. However, as we now know, the Supreme Court ended universal injunctions once President Trump, a Republican, was in office. So with that, I thank you so much for your time, and I look forward to the discussion.
Thanks, Ryan, for a very concise and informative presentation about the relationship between the Supreme Court and the Imperial Presidency. And I have to say this before I open the floor for questions and comments. I think the Constitution, has been amended. But some argument says that we have a frozen constitution in 18th century documents. And the problem that you delineated for us, Brian, is it shows they are also not the formal constitution, as I tell my students, but also the hidden and power relations that associated with informal and real politics, as Foucault would say, the effects of power on law. And the question is now is to what extent, what to do when the three branches of government are aligned for one political party. And the only reference I have, and you are the expert, you could correct me, is FDR, who was a powerful democratic president and was elected how many times? 3 times?
4 times.
4 times, right? And he passed away the 4th times, which is very unusual. So are we seeing, if we compare this very strong president allied with the 3 branches of government, something related to FDR, or this is a new terrain that is uncharted? And the larger question before we open the floor is what to do with the dilemma that you delineated for us. And the New York Times, I think last Sunday, even gives statistics that confirms what you shared with us about this, the conservative bloc and the Supreme Court, statistically voted all the time through partisan conservative support of the president today. So this is I don't know if this is a new problem or so, when the 3 branches of our federal government are aligned and controlled by one party. That's a heck of a challenge. But other than that, we'll open the floor after you maybe comment on this, and we'll start our conversation.
Yeah, so I think that's a really important question. I think it's certainly important to think about the differences between kind of the institutional kind of setup or structure that we have now versus in the 1930s during the Roosevelt administrations. Certainly right now we have a Supreme Court controlled by majority Republicans, we have a Republican president office, and we have a House and a Senate that are both controlled by the majority Republican Party. I think an important difference here is that the Roosevelt administration was one that had much larger congressional majorities. So at least on a legislative policymaking front, Roosevelt was a lot more successful in his domestic policy agenda than Trump is overall. Certainly Trump was able to pass the Big Beautiful Bill, but this was kind of the exception, right? What we're seeing in Congress, particularly in recent years, is a lot of legislative gridlock, where we have a House and the Senate that have, the majority party has very, very small majorities. So what Roosevelt was able to accomplish with the New Deal and in his legislative domestic policy agenda is something that's not really possible given the small majorities we see in the current environment. On the other hand, right, there is sort of the executive side of it. So, you can make an argument that Trump has prioritized, unilateral executive actions as a way of pursuing his policy agenda. The other interesting parallel is where the Supreme Court is. So there's kind of the famous story that we hear in the Roosevelt administration where Roosevelt submits his court packing plan. He says, I want to add a new seat to the Supreme Court for every justice. I think that was over, I think it was 70, or some advanced age at the time. And the conventional story is that the Supreme Court, notably Justice Owen Roberts, who had previously been striking down a lot of Roosevelt's New Deal, switched his vote, the switch in time that saved 9, so to prevent, right, this court packing plan from going through. That's the conventional wisdom. The problem with that is that a lot of the research that scholars have done says that Roosevelt didn't have the votes in Congress, that even though he had large majorities, they were not behind the court packing plan. So why Roberts changed his vote is not something that we necessarily know. He actually burned his papers, so we don't actually know what his thinking was, but at least the evidence suggests that it wasn't out of fear that Congress was about to accept Roosevelt's plan. The current Supreme Court seems willing to, at least allow the administration's policies to move forward by using this kind of emergency application docket, in addition to some really key merits cases that we've seen in recent years.
Thank you very much. Of course, the Great Depression was a bigger problem at that time than now, and FDR seems to be able to build larger consensus because of that, the collapse of the economic system itself. So there are differences. I agree with you. The floor is open for us to ask questions and also make comments.
Mike, yeah.
Thank you. I guess I kind of have a two-part question, or maybe some thoughts that lead to a question. And one is, I feel like today our arguments are way more partisan and way less principled. We're much more interested in winning and ensuring that our policy goals get met than we are in respecting tradition or separation of powers. It's a federal rights issue, and that's for us. It's a states' rights issue, and that goes for us. It's an executive issue, and that gets our policy goals. It's a legislative issue, and that gets our goals. And I feel like that maybe is a modern kind of, that's been increasing more recently. I'm curious your thoughts on that. And then I was also thinking about court packing as you were talking, and given your data about how Supreme Court justices tend to vote with the president that appointed them most and then the party of the president that appointed them second, why we're not seeing more efforts in that regard when we do have all three branches kind of lining up, and should we expect more of that going forward?
So just to clarify, the second part of the question is like why we're not seeing more court packing. So this is something that I think historically, if you look back at the arguments that were being given by the Democratic congressional majorities in the 30s to Roosevelt's court packing plan, and you compare that with the arguments that were being given during Biden's administration, they were really the same thing. And it all kind of amounts to an arms race between the parties. And I would definitely argue that if you look at congressional procedure and what both parties have been willing to do to limit the filibuster over the past decade, it certainly seems like this procedural arms race in that we are changing the rules of Congress so that we can get our policies passed more easily, that has come to fruition. The court packing one is, I guess the argument has always been, if we do this, what's to stop the other party from doing it immediately or once they gain power? And that's the same argument, right, that you're seeing in the 30s. That's the same argument that you're seeing, during the Biden administration. Practically from a conservative or Republican perspective, there's no reason to pack the court right now because you're getting the outcomes that you want. Right, it's already packed. But I mean, I think if you compare the two parties in their willingness to, quote unquote, go nuclear, right, with procedural rule changes, we do see that, the Republican Party at the national level has often seemed more willing to take those steps. Certainly, right, in 2013, Democratic Majority Leader Harry Reid did start the process of the nuclear option. At the time, there were a lot of President Obama's lower court judicial nominees who were being blocked by the filibuster by Republican minority senators. But what Harry Reid did was he said, okay, we're just going to change the rules. Filibuster no longer applies to lower nominations. Republicans saw that, and when President Trump had his first Supreme Court nominee, Mitch McConnell, the Republican majority leader, just said, okay, now the filibuster doesn't apply to Supreme Court nominees. And just a couple of weeks ago, Republicans actually, went nuclear again and allowed for multiple presidential nominees, largely of kind of an executive nature, to be confirmed all at once rather than one at a time. So the precedent is there, and it seems like it's just a matter of if there's a majority, like if there's enough of the majority party willing to take those steps, then they will do so. And so it certainly seems like the precedent has been set that the filibuster is not long for this world, right? Even for regular legislation. And for President Trump to pass the big beautiful bill, it required some, really procedural minutia around what's called the reconciliation process. So I think we are definitely seeing, right? I don't know, right? From Democrats' perspective, who have seemed less willing to take those steps, I don't know, like, if court packing will happen. From a policy perspective, it seems that Republicans are willing to do that. So, from a practical perspective, maybe it's in Democrats' best interest to do that too.
All right, thank you. Ariana.
So this is going to be a little bit of a kind of chicken and egg kind of question. And it's to do with that idea of like that legislative gridlock and partisanship. Do you think that the kind of growing prevalence of partisanship in Congress and the legislative gridlock has led to the kind of strengthening of executive power in the president just as like a means of we need to get things done? Or was it a case where the kind of strengthening of executive power made the role of the presidency more important, and which party the president was became more important, that bled into Congress, causing this legislative gridlock? Which one do you think kind of came first?
Yeah, so that's a great question, and it actually leads me into something I wanted to include in the presentation generally, but didn't have time for. To answer your question specifically, I think, it's not a great answer, but it's both. Certainly there were kind of practical necessities to having a more energetic and decisive decision maker, particularly in foreign policy. Congress, as I said, explicitly delegated some of this authority through various pieces of legislation or just unwillingness to really challenge the presidency. And there's some good research out there that I've seen that would suggest that Congress was willing to delegate this power because it didn't hurt them electorally. So when we think about our members of Congress, right, they are largely, their success is tied to the domestic sphere. So the president's always, at least in the modern era, right, foreign policy is seen as the president's role. So congressional members, who some political scientists have said are really just wanting to get reelected, right, that's their first goal, regardless of whatever else they want. Right? If they care about re-election, then maybe it makes sense for them to delegate this power away when it doesn't affect them, right? At least in an electoral connection story. I think what you're hitting on, the increase in polarization and gridlock, is actually, I think this might be a story of the Supreme Court as an imperial court. Right? So we could also have rephrased this talk entirely as presidential power and the imperial Supreme Court. And this is something that scholars have started to write about in the last couple of years, which is, this is a Supreme Court that is definitely willing to give, right, its favored political party presidents more power, but it's not because they think it's, it's necessary for democracy or anything, but it's really because, right, it fulfills their agenda, right? From a policy perspective, this is what, this is the direction they want to see policy take, but also it's a way for them to expand their own power. So I think what we're seeing in the Supreme Court is basically them saying, wait a minute, we've got a president and we've got a Congress that often can't get together to pass any significant pieces of legislation. So, we as a Supreme Court don't really have to worry that we're going to see retaliation from the elected branches. So we can feel emboldened to sort of make the decisions that we really want to make from an ideological or partisan perspective without fear of reprisal. Because yes, right, we currently have a Republican, a Republican Party that controls both Congress and the president, but their majorities are so small that any kind of effort to strike back at a Supreme Court, even if it was Democrats controlling, right, the presidency and Congress, without sizable majorities, right, particularly the Senate filibuster, the Supreme Court kind of feels emboldened to do what it wants. And, and what it's chosen to do is empower the current presidential regime because it's in their partisan interests.
Brian?
One is like just a very practical question that I should probably know the answer to. If the Supreme Court has used one of these, something from the emergency docket, like for example, the one a couple weeks ago that allows for ethnic profiling when ICE is enforcing the law, do they always have to then give it full can we always expect a fully argued and fully explained decision to follow something that was decided on the emergency docket? That's my first question. Well, I have another one. Is there anything we can learn, and this is probably too in the weeds to ask you to know on your feet, but I'm curious if you do. You said 84% of the time, right? They decide with the Republicans. Is there anything to learn from the 16%? Like the places they're not willing to go? Are there patterns there? And then finally, I'm genuinely curious, like if John Roberts was here and we were to put in front of him one of the times when he stopped Biden from exercising presidential power, like forgiving student loans, for example, and then presented him with, like, he must have some explanation. And do you have a gist of what he would say?
Yeah, so you might have to remind me of the three parts, but the first one is, the simple answer is we might expect it, but it might not happen because the Supreme Court is unique among high courts around the world because they have discretionary docket control. So they are allowed to pick and choose exactly what cases they hear every year. And they're choosing fewer and fewer to decide in their what's called merits docket. So the quick explanation here is that there are really two types of cases. There's what are called the merits cases, which are what we think the Supreme Court does, right? The lower courts have made their decisions. They've appealed it up to the Supreme Court. The Supreme Court has used their cert power to grant review. They hold oral arguments. They write full opinions explaining their decision. That's the merits cases. In the last couple of terms, we're seeing like 60 cases being decided that way every year. At one point, it was closer, even in the mid-century, we were closer to 200. So this has been a real pattern, especially under the current Roberts Court, to decide fewer and fewer cases on the merits. The other side are these emergency application cases. These have been increasing. The court's willingness to decide important issues using the emergency docket has increased. It is, see exactly what I was going to say here. Some commentators call this the shadow docket. So if you've heard the shadow docket, this is what we're talking about. But in general, what these emergency applications often are stays of execution. So a lot of the emergencies are someone who is scheduled to be executed asking for a stay. What's become more notable about the emergency docket is, the use of the docket for presidents or administrations to go in and ask the Supreme Court to keep their policy in place while it's going through the lower courts. And so that's kind of where we've seen the real change, where yes, there's fewer and fewer merits cases, but there are a lot of more important cases that are being decided on a temporary, often unexplained way in this kind of emergency or shadow docket. So that's kind of the answer to the first question, is basically maybe, if the court wants to, because they have discretion. A lot of these cases probably will eventually be heard by the court, just because of the importance of them, and we can kind of read the tea leaves from what the court has decided with them. Usually, for these emergency applications to be granted, we call these stays. The Supreme Court basically has to think that the litigant has a good chance of winning on the merits. So the Supreme Court is signaling that the administration has a good argument. And so the second question, remind me, because I
Like the 16%
yeah.
would
Yeah.
Is there something
some of these are, Abrego Garcia, right? The Supreme Court used one of those three, I believe, was saying, bring him back, right? You've gone too far. So yes, there are some extreme versions where, like, yes, there's maybe an argument that even the Supreme Court thinks that some of these immigration decisions are, too far.
But I think, Ryan, the question, one of the questions that Brian asked is still a mystery. Justice Roberts, he was voting for up until recently in the center, and sometimes even sided with the liberal minority of the Supreme Court. It's really a mystery to me. And you said also, you shared with us that he burned some of his
Or Owen Roberts, so the 1930s.
1930s.
Yeah.
It's a mystery that what happened to him, because I was reading a very important article in the Times last Sunday, and I really recommend it to all of you, because it's really it goes into statistical analysis of the justices' voting patterns, and also it tells us a really a clear picture, more partisan as you presented to us, but also we want to know their perspective, what really happened, and Justice Barrett also had a long interview. I don't know if some of you probably seen it or not. She was really I was waiting for something to enlighten us about her rationale. But she went into really this closed way of thinking. This is the way it is. This is the Constitution. I don't care about all the protests against my vote.
Yeah, so the third question about, so what do we make of Chief Justice Roberts? Right, so there, for probably the first 10 plus years of the Roberts Court, we're now roughly in the 20th year. I think he was appointed 2005, 2006. So the first 10 years of the Roberts Court, Roberts sort of had this reputation as an institutionalist, someone whose primary goal was to make sure that the Supreme Court maintained its credibility and its legitimacy and maintained its power. So, the kind of case in point in this is the first Obamacare decision, the NFIB versus Sebelius, where Roberts surprised a lot of people by not only ruling with the liberal bloc of the court to save the individual mandate of Obamacare, but also wrote the opinion and used an argument that many didn't see coming, that it was, not a Commerce Clause question, it was a tax question. So, the narrative about the first 10 years about Roberts was that, yes, he leaned conservative, but his most important objective was to make sure that the court was still seen as legitimate. It's a little harder now in the more recent cases to sort of, think about how that squares with the earlier Roberts as institutionalist. Roberts himself, like all justices for the most part, when they're talking in public, their rhetoric is always, we make decisions based on the law, right? We're umpires, right? And this is legitimacy. This is about ensuring that the court is still seen as credible, even when they make decisions that you may disagree with. So in one way, right, I think Roberts may recognize that in some ways he's no longer the swing justice. So if you look at the current 6-3 court, Roberts is probably, the number 4, right, in terms of, from most liberal to most conservative. He's probably, slightly less conservative than Kavanaugh. So Kavanaugh becomes our swing. So what we have seen Roberts do is often take opinions for himself. So, even we might have expected that Roberts would be a lot more institutionalist in these opinions, but he certainly has some opinions that seem to go pretty far, right? If we think about the presidential immunity decision back in 24, right, it's a very clear, right, presidents are pretty much immune from criminal prosecution for anything that's an official action or part of their core constitutional function. And that's, Roberts' opinions have created these pretty broad legal rules. So it is a mystery. It could be partly that he has a particular, recognizes that, he's no longer the swing, so he can take opinions for himself and just, write the opinion as slightly less conservative maybe, but, it's still creating these important legal precedents that do lean conservative. And I know that's not a satisfactory answer.
Yes. Well, I mean, it's true that he referred to, and I think that I'm like a referee, except that referees sometimes errors, and sometimes they get the Super Bowl to not the Seahawks, but some other rival team, my team. Let's get there. Yeah. Um, is the Supreme Court, as a branch of our federal government, very important and supposed to be really, as you said, one of the strength of the Constitution, the Supreme Court justice are, are not elected and purposely to be autonomous and they have that security. They are 10 years, long time ago. But one could argue historically that the Supreme Court of the United States hasn't been like this, has been behind society, changes that granted equality for many, many excluded segments of society, women, minorities, Afro-Americans, and others. And only maybe in the 20th century, the second half of the 20th century or 20th century, and you are the expert on that, that the Supreme Court began to really sometimes take a more daring decisions. Is this fair statement, or that's really misleading myth?
So I think the question here is, like, has the Supreme Court historically been sort of a protector of minority rights, of expanding
And women,
and
and
women,
other
yeah.
groups, yes.
I think the answer is, when you look at the Warren Court, yes.
Before that.
But before that,
Yes.
maybe not.
Yes.
Because certainly we look at Dred Scott, right, in the Taney Court. We look at Plessy versus Ferguson in the, I think, Melville Fuller Court in 1896. You look at even, before Warren, right, we had the Korematsu decision that was written by a Warren Court justice, Hugo Black, which interned Japanese Americans during World War II.
Yes.
So I think the Warren Court may be the exception, and I'm not a legal historian, I'm not a law professor, so please, I'm willing to be corrected on this, but my sense is that we look at the Warren Court from 53 to roughly 68, 69. That's the high point of progressivism, of liberalism on the Supreme Court. And what we see with Berger, Rehnquist, and now Roberts has been varying degrees of, pushing back on those broad precedents that were created in, criminal procedure or, with desegregation and busing. We've seen
Voting rights.
We've seen Miranda have bunch of exceptions. We've seen exceptions to the exclusionary rule.
Right.
But a lot of, particularly from a criminal justice perspective, right, a lot of the big due process protections that we think about today for people who go through the criminal justice system, that comes from the Warren Court in those roughly 16 years or so. And everything else has been like qualifying those decisions.
Yes, and also we have to also remember that President Trump reference point is not that period of change. His reference point before the middle of the 20th century and the civil rights movement, and also talking about late 19th century and first half of 20th century before the New Deal. So I think we have a clash of references and a clash of heritage and what's make the court and our system progressive or great or not great in that sense. James.
Maybe on a positive note, right? I mean, the process is messy, and it's been messy from day one, right? This idea that everything's laid out clearly and everyone's breaking the rules all of a sudden, really, I mean, it just, I'd go back, you mentioned Marbury, right? I mean, Jefferson would say, I wrote the darn thing, and that's not what we wanted the Supreme Court to do. And of course, Marshall was a Supreme Court justice who worked for Adams, who was a political enemy of Jefferson, and the whole judicial review concept was inherently political and messy and a power grab. And we could go through, I mean, the fact that we got the Civil Rights Act got passed really because of the way we got the Commerce Clause interpreted, which is probably not exactly what they were thinking when they did it, right? So my point is these things have unintended consequences, and I think what you pointed out, Ryan, at the beginning, which is ambition, pushes back on ambition, right? And that's probably the beauty of the U.S. Constitution. That, because I always tell students, constitutionalism is about one irrefutable fact. Anyone, or any group who's ever been empowered, since the beginning of time, will seek to do one thing, and that's grow that power. They may do it for good reasons or bad reasons. They'll always try to do that. The Constitution recognizes that and just tries to put it in enough systems that ambition checks ambition, right? And so, eventually that power of judicial review ended up being what the Warren Court gave us in so many different sort of important aspects. And the alignment between the Supreme Court and the Congress, politically, ideologically, that's not going to last, right? I mean, you just mentioned Roberts is an institutionalist in many ways, I think, and their interests are going to be separate from the other interests, and that'll change to another court. All those aspects will change, and so that doesn't mean not be on guard or not protest or be vigilant on these aspects, but have a little bit of faith in the ambition checks ambition. And it's going to be messy, and it's not going to be clearly obvious or consistent, but that aspect of the U.S. Constitution, I think, is its best feature, and I do think it will be a curtailing force, ultimately, as we go on.
Well, this is a positive. We shall overcome, and things are okay. I like the tone.
Yeah, I think that's a really important point. I say, I guess a qualified, I certainly agree with that. My qualified answer would be that, this separation of powers, checks and balances system, I think works because historically we have seen our institutional actors kind of operating in good faith, right? So, there is no specific mechanism in the Constitution for how the Supreme Court's decisions are going to be carried out, right? They don't have an army. They can't, appropriate money. So the Supreme Court, as Hamilton tells us in '87 Federalist paper, right, the Supreme Court's decisions rest on the public sustaining them and the executive being willing to enforce it. I think there, with for example, the Abrego-Garcia case, right, there was concern, right, that the Supreme Court seemed to be saying, do this, and the presidential administration basically making an argument that they didn't have to. And so I think there is some concern, right, in making sure that we have, political actors who are operating in good faith and abiding by, right, the structures that they have. But, we did even see in that case that the Supreme Court said, this is too far. So, I think that is, I'm hopeful that, the system we have in place will continue to provide that, but I think there are signs that we have to rely on, actors operating and arguing in good faith for the system to fully work.
Okay, other questions or comments? I think needless to say that the strength of our Constitution is when you have balances, as you said, check and balances here. Right now it's off. Let's hope that what James said, and many of us with goodwill, by voting and by participating in the political process, that will make sure that will be put back in order for the sake of everybody, not only one party or one way of thinking. And this is the only way we could make things work the way we would like to have in this country. Right now, it's needless to say that we are divided. And I don't recall any time since I came here as a young man for graduate school, I've seen this division. That's not to say, as you explained to us, Ryan, and the history is, contested, complicated, And the Supreme Court never been that glamorous, working in a certain way, especially if we look at the history of struggles in this country that expanded democratic rights and legal and constitutional equality. And I think there is no escape but to be involved more and more, as you explained to us today. So I want to thank Dr. Williams for a very, very informed and very precise, knowledgeable background of the issues. I want to thank all of you for coming in this beautiful day. The sun might be back maybe later on. And thanks, Carl. Thanks, Lee. And we conclude our Constitutional Day.
Thank you so much.